All right. So today we're going to talk a little bit more about the judicial process before we segue into Marbury versus Madison, which will launch us into the next section. We're going to talk about some things about the United States Supreme Court that make it fairly unique in its design. And one of those is the caseload. So when we look at the caseload, we have to realize that the caseload of the United Supreme Court has declined considerably over time. So that is, the number of cases that the Supreme Courts decide in a given year has dropped significantly. And that beginning of that significant drop comes with the enactment of the Judges' Bill of 1925. Now, the Judges' Bill of 1925 did a number of good things for the judiciary. But most central to this idea of caseload is it gave the Supreme Court what is known as discretionary jurisdiction. Now, discretionary jurisdiction is the ability of a court to decide what cases it wants to hear. And so if we look at the caseload over time from the United States Supreme Court, following the passage of the Judges' Bill of 1925, we saw the amount of cases that it decided in any given year drop significantly. I think last year the court formally decided 81 cases. But if you take the timeline back even 30 years before that, they were deciding 150, and we'll take a look at what that looks like. So as I mentioned, discretionary jurisdiction, and also the court also during this timeline, really from 1925 onward, sort of signaled to litigants that it was no longer going to hear a large number of economics cases. It wasn't going to hear as many federalism cases. It was really going to focus on the jurisprudence of individual level rights, which means that the court was going to be much more involved in protecting and enforcing the Bill of Rights and also other civil rights laws that were passed during this time period. And so we see a much larger percentage of the cases that the Supreme Court decides to take have to stem from this individual rights pursuit of the court. We've also noticed over this time that there's been a decrease in signed opinions, meaning that the Supreme Court is taking less cases, and they're also dealing with the cases that it decides to take in some different fashions. So most of you probably think the Supreme Court had grants certiorari, which is the process by which the Supreme Court decides to hear a case, is granting certiorari. And then they schedule oral arguments, they have oral arguments, they meet in chambers, they write an opinion. That happens for the majority of cases, but a non-trivial amount of cases are handled without oral arguments. Another non-trivial amount of cases are granted cert, but then remanded back, giving pending orders of other decisions. And so we see a lot of what we would call dispositions that end a case, but aren't signed opinions. They aren't orally argued and they aren't formally signed. So that's another interesting increase over time. And the reason why is I want to take a look at this timeline right here. I hope you can see it. If not, I think, hey, I remember how to increase the size of, the screen. So this is the number of petitions granted by the United States Supreme Court in a given year. And the most recent years are literally right behind my head. So I fixed that. And what you can see is that even in the 1970s and even in the early 80s, what the court is granting cert to 150 cases in a given year. Well, in 2015, that had dropped down to 81. And I think if I said last year, the Supreme Court also heard 81 cases, or granted cert to 81 cases. One of the reasons why we've seen a precipitous drop really beginning in the mid 80s, and we can kind of see the curve drop off very clearly then, is because the decision of the court, the way that the court makes a decision, is by simple majority. So the court, the most important number on the court is 5, because 5 people have to agree with you in order to make a decision. But the way by which you grant cert, so the voting in chambers to decide to hear a case, that's done by the rule of 4. So only 4 justices have to agree to hear a case, but 5 justices are needed to have any outcome in the case, what we call on the merits. And beginning in this timeline, really around the mid-'80s, what happens is the 5th position on the court, the median justice is how we call it, began to be less predictable. And so we had a 5-4 split for a vast majority of this period, in which the swing justice could go, really in a liberal direction, or could go in a conservative direction. So the court, in response to this, began hearing less cases, because if you are a minority of judges, if you are 4 judges who want to hear a case, the primary reason why you want to hear a case is because you want to overturn the lower court's decision. Well, that's a really risky bet if you don't know how that 5th member is going to behave. If you're certain that that 5th member is going to vote with you, then absolutely you'll vote to grant cert, hear the case, overturn it. But if you don't know how that 5th member is going to vote, even though you want to overturn the case, you probably won't hear it because you aren't certain of what the outcome will actually be. And this goes for both liberals and conservatives during this time period. But notably, now we don't have a 5-4 majority on the court. We have a 6-3 majority on the court. And so the median justice isn't nearly as centrist as what would happen in a 5-4 court. So I would expect, if we were to extend this timeline further and be able to jump ahead and look a couple of years from now, I would expect the Supreme Court to start hearing more and more cases, largely because they're better able to predict what the outcome on the merits will actually be. So discretionary jurisdiction has sort of created a more internal political game for justices, in which they try to predict how their fellow justices are going to vote in any given case. Questions about that? And again, mute or unmute or write it in chat. All right. So while the Supreme Court does have discretionary jurisdiction, there are a number of what we consider threshold issues that the court uses and also continues to use, and you'll be familiar with some of these, to not hear cases. Perhaps the largest constraint on the Supreme Court's ability to hear cases comes from Article 3 in the Cases and Controversies Clause. So in order for the Supreme Court to hear something, it actually has to be an ongoing case or controversy. What that means is the 2 sides have to actively be contesting each other and disagree on the outcome. Furthermore, they can't have already settled the case. The case can't have been resolved in another fashion. So it has to be a current case or controversy. It can't be a hypothetical case or controversy, and it can't already be a settled case or controversy. It has to be current and ongoing. And Article 3 provides this restriction. Now, one of the reasons why the founders put this restriction upon courts is because they didn't want courts to issue what are known as advisory opinions. Advisory opinions, many courts, even in the United States, use this. Many state courts have advisory opinions. And what advisory opinions are is the legislature wants to pass a law, but they aren't sure if it's going to run afoul with the Constitution or conflict with other laws. So they ask the Supreme Court to weigh in. Like, hey, can you tell us if this law as drafted will meet constitutional muster? The Supreme Court can't do that. They can't weigh in on hypothetical situations because of the restriction in Article 3, which mandates that they only hear cases and controversies, and a hypothetical isn't a case or a controversy. So the Supreme Court very early on has sort of instituted this idea that this case and controversy requirement basically is a prohibition on the federal courts from issuing what are known as advisory opinions. So this cuts down on the ability of the court to weigh in before a law is actually passed. Now, many states have instituted in their state Supreme Courts the ability to issue advisory opinions. And it hasn't really ground the wheels of justice to a halt. So perhaps the federal prohibition is unnecessary, but since it's in the Constitution and this isn't a vibrant issue that everyone wants to get rid of, it's really never come up. So this case or controversy restriction on advisory opinions still stands. Another issue that is sort of tied to this cases and controversy is a thing called declaratory judgments. There's a prohibition on declaratory judgments as well. And they're different. So declaratory judgments are basically this: a law is passed. However, it's not entirely clear, certain parts of the law, what it means and how it would be enforced. And a declaratory judgment would be asking a court to clarify how the law should read and how it should be interpreted. In that situation that the law itself has not been enforced, however, there is no or controversy. And therefore, the Supreme Court most of the time does not issue judgments in which the text of the law hasn't been enforced. So the law itself has not been used yet, because they claim that there's actually no individual harmed unless the law is enforced. So there's no actual harm. There's no hurt, so to speak, if the law is not enforced. And therefore, since there is no case or controversy, they can't weigh in. In very rare circumstances, they will weigh in before a law is enforced. And you've probably heard this a lot in the past few years, what are called a TRO, a temporary restraining order, which prevents the law from being enforced until it can be adjudicated. Those are rare. Another thing is this adversarial nature, this case or controversy. Make sure that both sides of the case oppose each other. So it has to be someone versus someone else. It cannot be simply an individual challenging a law and the government not wanting to defend said law. The government has to want to defend the law. So there have been circumstances in our country's history where individuals have challenged a law and the federal government, mainly the executive, went, well, we're not going to continue to enforce that law. It's bad. Or we're not going to continue to enforce it in that way. And in those circumstances, there's no case or controversy because that individual or that group of individuals who are bringing suit, they agree with the other side in the case. And so there's no adversarial nature. There's no controversy for the court for which the court can resolve. There are more threshold issues. One of the biggest and one of the ones that we heard about throughout the entire post-election season and through now is known as standing. And standing is simply the ability of the party bringing suit to actually be qualified to bring the suit. First off, and this was a very large hurdle in which most of the post-election cases could not meet, and that was the party bringing suit had to actually suffer injury. Sometimes proving injury that you have been harmed is always enough. Sometimes alleging that an injury has occurred is enough. But there has to be, in some way, the party who is bringing suit has to have been harmed. The argument of why almost all of the cases that were brought in the post-election period challenging the voting laws is that the individuals who brought the suit weren't harmed in as much as their ability to vote was unchanged. And so they were not seen as being harmed because the change in the law did not restrict their right to vote. Since they weren't hurt, their individual right, their ability to vote, was not harmed. They don't have standing to bring a suit because they were never actually injured in the changing of the laws. Another part of standing is you have to be able to demonstrate a causal connection between injury and conduct. So you have to demonstrate, and this happens primarily in civil suits and tort suits, you have to demonstrate that your injury is the result of negligence on behalf of the other party. So in for example, a slip and fall suit, you have to demonstrate that if but for negligence on behalf of Walmart, you would not have slipped and broken your hip, for example. So you have to demonstrate that there's a causal connection between their negligence or action and your actual substantive injury. Furthermore, you have to demonstrate that your injury can be redressed. This is sometimes difficult. However, we in the United States lean very heavily on monetary redressment, meaning that money can solve everything. So even if, for example, a family member of yours' right or life was illegitimately taken by the federal government or by armed forces or by police, there's no way that life can be redressed. They can't bring him back to life. That's simply impossible. However, it can be redressed, at least within the United States context, through monetary reward. There exists an exception to this standing doctrine, and that's known, or the standing rule, and that's known as the Flass Doctrine. And the Flass Doctrine is a doctrine that gives taxpayers standing. First off, there has to be a logical connection between an individual's tax status and the legislative statute. So that you have to be able to draw a direct line. Oh, okay. You have to be able to draw. I hit the escape key. Yep. You have to be able to draw a direct line between an individual's taxpayer status and the legislative statute that is being challenged. And you also have to connect this taxpayer status with the precise nature of the infringement. What this means is that most taxpayers can't bring suits just as a taxpayer. So like, I reject this law Congress has made on the basis that I'm a taxpayer and they're using my money and it harms me. That's not enough in most cases. There has to be a much more direct connection between your status as a taxpayer and the way the government is choosing to use your taxable income. It does provide some taxpayers under some instances with standing, but generally most taxpayers won't have standing to bring suit. Questions about standing before we move on? Cool. And we're going to move to mootness. This comes from the idea of the current case or controversy restriction in Article 3. If the case has been resolved, then the case is considered moot. And that means that the court can't resolve it, that it's unable to resolve it. Don't worry about the fundus. There, however, is an exception to this rule. And that exception comes from Roe v. Wade. So let's think about the nature of how long it takes from a case to get from the trial level to the United States Supreme Court. We talked a little bit about this last class, but the process is is long. In some cases, upwards of 5 years. Well, the nature of a pregnancy isn't that long. At the most, we're talking 40 weeks. The idea of this thing being able to escape review because of its nature of how it's bound in time, the Supreme Court realized that if they did not make an exception to the Mootness doctrine, they would basically never be able to weigh in on cases like abortion that happen in a short time span. And so they developed this exception to the Mootness doctrine that has then been extended far beyond just simply abortion cases. And that exception is if the event that is being examined is capable of repetition, but even in that repetition can evade review, then the Supreme Court will make an exception to its Mootness doctrine. So in this particularized case in Roe v. Wade, the baby was already brought to term. However, it's very easy to see how other individuals in a very similar situation would never be able to get their cases heard because of the timeliness of the action, or the timeliness of pregnancy. And so while this is an exception to the Mootness doctrine, it's very limited. And so let's say, for example, you sue the federal government for X. But in the time before you appeal to the Supreme Court, but between the time you appeal to the Supreme Court and the time the Supreme Court is going to hear your case, the law itself is changed. The thing that you were alleging was unconstitutional is changed, either through executive action or legislative action. Well, at that point, your question has become moot, because that thing that was harming you is actually no longer harming you. And so there's no reason for the court to weigh in on that because it's now become hypothetical. And so your individualized case would be rendered moot in that circumstance. There are now a number of exceptions that fall under this capable of repetition yet evading review exception, but understand that they all come from Roe v. Wade. Roe v. Wade is sort of the starting point for this mootness exception. There are a lot of interesting things that come out of Roe v. Wade that have absolutely nothing to do with abortion. And this exception to the Mootness doctrine is just one of them. Another issue that the Supreme Court sees as a threshold issue, that is an issue that prevents them from hearing cases, is known as ripeness. One way to think of ripeness is like it's the inverse of mootness. If mootness means that the case has already been resolved by another actor, ripeness means you haven't given other actors enough time to resolve the case. What this means is that if you have not attempted any sort of bureaucratic, administrative, state-based remedies that already exist to solve your problem, then going through the courts is absolutely premature because you haven't exhausted your options. If you, for example, are incorrectly detained by the police, your first course of action isn't to go to the court system. It's to request the police no longer detain you. And if the police cease detaining you, then there's no need for the court system. Take that and extrapolate it much broader, and that's this issue of ripeness. If you simply have not exhausted bureaucratic and administrative and state-based remedies, then the judiciary is simply not the appropriate venue for you at this time. You should try other mechanisms that are available. There are some cases where you can ask courts for preventative relief, meaning that if this law is enforced as intended, my rights will be irrevocably harmed. There's no real hard and fast rule with regard to how courts handle preventative relief. And that means that there are lots of cases that seek preventative relief alongside other issues, because there is no hard and fast rule for preventative relief. But More often than not, courts don't engage in preventative relief until the law is actually enforced, because the argument is, well, your case is simply not ripe. Your case simply hasn't gotten there yet. Courts, however, have developed, and mainly the United States Supreme Court has developed this mechanism where they use ripeness as a means to simply dodge cases. That they will say, well, that case is unripe for us to hear, or you haven't exhausted all of your options. And what they're using it, and they use a number of these threshold issues, by the way, to simply not hear certain types of cases. For example, the first state to pass a gay marriage or gay unionship law did so in the mid-90s. The Supreme Court didn't take that up until 2013. Do you think that means there were no cases that came before the court asking them to recognize or, dismiss this right that had been carved out? And the answer to that is absolutely not. Of course, there were a number of cases. But one of the familiar returns of the court is that you haven't pursued all other options that are available to you to get relief. And as you can imagine, that was the mechanism by which they were using to simply refuse to hear these cases. So ripeness sometimes is a little bit more difficult standard to sort of demonstrate. Questions about mootness and ripeness? What encompasses injury? It's not just physical. No, it's not just physical. It can be emotional or financial. Yeah. It really depends on what the nature of the injury is. So if you have been physically violated in some way, that you were physically harmed, demonstrating that is usually fairly easy. Like, I broke said limb, I have all of these bruises. That tends to be much easier to demonstrate. But demonstrating this sort of emotional harm is more difficult. And so all of these are types of injuries that individuals can allege. Easiest, obviously, is physical injury. Second easiest would be monetary injury. So, for example, in the process of me breaking my legs, I was unable to work for X amount of months, and therefore they're not only liable for damages with regard to my actual physical well-being, but they're also liable to the income that I lost because of their negligence. Then emotional can get tagged on. And let me make it more simple. I don't care in large parts about all of those types of injuries, because that's fully beyond the scope of this class, and enjoy law school. But I simply use it to say that injury actually has to exist in order to have standing. And any of those types of injuries of which you assess or which you brought up are actual injuries. Next question. Can ripeness be used based on prevailing societal opinion to refuse to hear a civil rights case that has strong negative support? I suppose. Ripeness is a funny tool, and courts can use it to dodge any sort of thing they don't want to hear. There are more than a few instances which I could point to in which a court refused to hear a case as unripe because it was happening during an election year, and then they resolved it after the election happened because they didn't want the outcome of the case to affect the election. And that happens not infrequently in civil rights cases, because the Supreme Court decides something, then it immediately becomes an electoral issue. And so they can use ripeness as a means to dodge it. They're like, oh, well, the case isn't ripe. And it turns out immediately after election, oh, look, the case is ripe now, where logistically nothing has actually happened in that small amount of time. So ripeness it is more of a tool for courts to dodge cases than it is actually really a barrier to entry, though oftentimes it is a threshold issue because it's not hard to imagine that your rights, the government has denied you of your rights, but you didn't ask them to resolve that issue and immediately went to the courts. So you could see how that circumstance would come up as well. But it is still used by courts to sort of dodge some of these issues as well. Other questions on mootness and ripeness? All right. Now political questions. If you thought ripeness was a means by which to dodge cases, well, welcome to the political question doctrine. There are 6 criteria under the political question doctrine. And generally, the Supreme Court states that there is a prohibition for them handling political questions, and political questions sort of meet these 6 criteria. If you meet one of these criteria, that can be considered a political question. First, if there is a textually demonstrable commitment to a political department of government, generally considered executive or legislature. So if there is a textually demonstrable reason why the executive or legislature should have exclusive ability to decide in this area, then it becomes a political question, and court shouldn't weigh in on it because that power is given solely to the executive or solely to the legislature. Second, if there are a lack of judicial standards by which to resolve the controversy. So simply that the courts would be, in essence, making it up. If, and my favorite of the list of 6, if there is an impossibility of deciding. Let's say, for example, the Supreme Court was thrown the outcome of an election and asked to resolve it. That might be an impossibility of deciding circumstance, but we can totally look back at our history and see a circumstance where the Supreme Court absolutely did decide the outcome of an election, and so who knows? Fourth, the inability to disrespect other branches. So the Supreme Court won't resolve an issue if it would besmirch and disrespect the other 2 branches of government, or one of the other 2 branches of government, or both even, in the instance of deciding the case. If there is an unusual need to adhere to a certain type of policy unquestioningly. I would imagine, as the court often does, this would be a sort of time of national security sort of instance. And the last one, the embarrassment that would arise from multiple pronouncements of policy. So, for example, if the Supreme Court made a decision and the executive said, well, yeah, nope, we're not going to do that, they wouldn't hear it as a political question because there would be an embarrassment of multiple pronouncements of policy. I don't think embarrassment is really what they're looking for here, but that's the word they definitely used. Now, it's hard to imagine any number of high importance cases that the court has decided within really the past 20 years that don't run afoul of at least one part of this doctrine. In fact, many individuals smarter than I would say that in almost every case the Supreme Court decides run afoul of at least one of these criteria. And remember, if there's even one, the Supreme Court should state that, oh, that's a political question and therefore we can't weigh in. So what does the Supreme Court ultimately use this political question doctrine for? They use it to dodge cases they don't want to decide. That's simply what it is. They've made this of cases or criteria so broad that almost every case can be considered in some shape or form a political question, which means that this is a handy way for the Supreme Court to completely dodge an area when deciding a case would be bad for them. So, for example, if some of the Trump challenges had made their way to the Supreme Court, I would not have been shocked at all if the court said, well, nope, that's a political question. It needs to be decided from the elected branches of government, and we can't weigh in. They would have totally dodged it completely. And so this political question doctrine, it's kind of a mockery at this point. We understand it exists for some, important reasons, but it also is a mechanism by which the Supreme Court kind of shields itself from any sort of really dangerous issues for it to decide or politically dangerous issues for it to decide. So there is no one responsible for making sure the criteria isn't met? No. So let me get this one out of the way. Who makes rules for the United States Supreme Court? The United States Supreme Court. It makes its own rules. So, yeah, they get to decide whatever they want, whenever they want, because they're independent and because we've made them that way. But it also means that the rules by which they're governed are generally made by themselves. Certain things aren't, up to them, like discretionary jurisdiction can be taken away from the United States Supreme Court. But beyond that, political question doctrine is just one of those examples of rules that they've come up with themselves. For that matter, the Mootness doctrine, the standing, Ripeness, those are all developed by the court. No one told them that these things existed. The court themselves said that these things exist. And to think of it more broadly, oftentimes you'll hear in popular media, though, Judge so-and-so should have recused themselves, meaning that they had some sort of interest in the outcome of the case, or they were biased with regard to one of the parties of the case, and therefore they shouldn't be sitting to hear that case. Well, they're the ones who get to decide. No one outside gets to decide that. The Chief Justice can urge someone to recuse themselves. The judges collectively can urge another justice to not sit in a case in which there is potential bias. But the only individual who can actually decide that they're going to recuse themselves is the person who would be recusing themselves. So the Supreme Court is this institution that is not accountable to largely anyone. And that's one of my strongest critiques of it, but also one of the biggest benefits of our court system is that it can't be directly influenced politically, that it is pretty immune from external persuasion. So that, really the only way that external sources can influence the court in any sort of large fashion is through who gets on the court. That's why people battle so hard over nominations to the Supreme Court, is because it's really the last time you get to affect how that individual or how the court is going to behave in some sort of systematic fashion. Because once an individual's on the court, they're there for life. They're independent. You really can't mess with them. Sure, you can impeach them, but it happens so absolutely rarely. In fact, to talk about the last judge that was impeached, you would have to go back to 2010. And the only reason that's in my mind is one of your senators, John Cornyn, yesterday said that an individual, a member of the Senate presiding over an impeachment trial was unprecedented, because that means that they would be presiding over the trial and also a juror. And it took me 2 seconds to go, well, wait, that happened in 2010. And also, John Cornyn, you were a senator in 2010. So John Cornyn, you're not, well, maybe you just don't know what the meaning of unprecedented means, because like it literally happened while you were there. But that's neither here nor there. That generally judges can't be impeached. The judge who was impeached in that question absolutely had to be impeached. There was no questions in that case. But judges more often than not aren't impeached because they decided cases the wrong way. In fact, in the history of the federal judiciary, that simply never happened. So they're just independent, and you just kind of you want an independent judiciary. Well, we've got one of the independentist. If you want an accountable judiciary, you've got to look elsewhere. We really went as far as we can on the independent route. Other questions? All right. Okay, so how do cases get to the United States Supreme Court? First way is through original jurisdiction. There are generally three types of cases that come into original jurisdictions. So cases involving ambassadors and consuls, cases involving treason, and also suits between two states. Those are kind of the original jurisdiction cases. Most of those don't come up. In any given year, there's usually one or two original jurisdiction cases, and those cases usually are California and Nevada suing each other over water, or Tennessee and Kentucky suing each other over water. That's usually it. And the Supreme Court has to hear those cases because they're mandated in Article 3. Past these original jurisdiction types of cases, the Supreme Court has appellate jurisdiction, which means that it hears the vast majority of its cases on appeal. Now, the source of these cases is from the United States Courts of Appeal or state Supreme Courts. They can come from either area. So either these are federal appellate courts or state Supreme Courts are where these appellate cases come from. And these make up the overwhelming majority of the cases that the Supreme Court decides. And as I mentioned earlier in the class, the reason why they have this authority is because of the Judges' Bill of 1925, which gave them discretionary jurisdiction, which simply means they get to decide which cases they hear. The method by which you appeal a case from either a federal appellate court or a state Supreme Court is to draft what is known as a writ of certiorari. A writ of certiorari is simply a request, is you requesting that a higher court, in this case the U.S. Supreme Court, call the case up. That's simply what certiorari means, is to call up, to certify and call up. And so you're asking the Supreme Court to take this case from the lower court and put it upon their docket. One thing to note, and this bothers students to no end, but the Supreme Court itself is not an error correction court. What do I mean by that? If your case was decided incorrectly, but similar issues of law were decided correctly in almost every other case, then the Supreme Court won't take your case. Even though the law was applied incorrectly to you, that doesn't matter. The Supreme Court exists to make sure that there is uniform consistency in the law. And if one case is decided incorrectly, an incorrect application of the law, that usually doesn't reach a standard that the Supreme Court will hear that case. What increases the likelihood of the Supreme Court hearing that case is if, let's say, for example, the Fifth Circuit Court of Appeals, which we reside in, decides an area of law very differently from the Ninth Circuit. So we have two circuits which are applying the same law in different ways. The Supreme Court will hear that, will most likely hear that, because you have two areas of the United States that are in function under different enforcement of law. The law is being enforced differently under those two areas. But if just one person in the U.S. has been a law has been misapplied to them, the Supreme Court's not going to hear that. The Supreme Court doesn't exist to correct individualized errors. It looks at the judiciary and the justice system in a much more holistic and broad sense. So what are some things that can increase the likelihood that the Supreme Court will hear any given case? Well, the Supreme Court in its own rules kind of sets out some of the things that they look for, particularly in the Supreme Court Rule 10. They note that if there exists conflicts between the circuits, so if the circuits disagree, for example, like the Fifth and the Ninth, they disagree in the application of law or how a law should be interpreted. Another example would be if there exists a conflict between a circuit and a state court. So a state and the circuit courts are deciding a similar issue differently. Another example is if the state courts are deciding federal issues. State courts generally don't decide federal issues. They decide most issues based upon state law, which is what they have jurisdiction over. So all of these things sort of increase the likelihood that the Supreme Court will grant certiorari and hear the case. There are some other factors that aren't within its own rules, and this is what political scientists have learned from data crunching. One, if the Solicitor General tells the Supreme Court to hear the case, the Supreme Court's probably going to hear the case. The Solicitor General is the attorney for the United States. So it's more formally known as the Office of the Solicitor General. This office, the individual who is the Solicitor General, is third in line of succession in the Department of Justice. But the sole job that the Solicitor General and the individuals within their office have is to represent the United States before the Supreme Court. But they can also participate as amicus curiae, that is, friends of the court, and submit briefs to the court, urging the court to decide one way or another, or to simply hear a case. Well, when the Solicitor General's office urges the Supreme Court to hear a case, even if the United States isn't party in it, the Supreme Court is probably going to hear that case because of a lot of reasons. But the Solicitor General's participation really increases that. Another thing that increases that, if it's a substantive area of law or substantive area of policy that the other two branches of government are just absolutely ignoring, that they're just not dealing with. Civil rights, for example, gay rights. If you have these issues arising that the other two branches are just not dealing with, the Supreme Court's going to deal with them. And the reason for that is partially also because of their independence. Because they aren't beholden to electoral forces, if they make a decision in a substantive area that the other two branches of government have not addressed, it's not like they're going to get voted out of office. They might become unpopular for a time, but it's not going to affect them in the long run. Whereas the other two branches of government might strategically dodge a substantive issue because there might be electoral consequences. So during those times, the Supreme Court will on occasion sort of step in to this void that the other two branches of government have left. All that being said, 95%, I think it's actually higher now, I think it's closer to 97% of all writs of certiorari are denied in any given year. So remember I said that I think last year 81 cases were granted cert by the U.S. Supreme Court. What that means is a little over, I think, 15,000 petitions for cert were sent to the court, and they ultimately heard 81 of them. So you can see there's a vast gulf between requests for review and actually getting reviewed. So what sort of affects this process? Nope, we don't need this for the class. So I'm going to skip it. I'll also cut it out of the video. I'm going to cut that out of the video and cut that out of the video because I really just want to get to the case. We'll talk about this. So the one thing that we need to know is that there exists something on the Supreme Court called the Cert Pool. So how does the United States Supreme Court decide what cases it's going to hear? If it gets 10,000 petitions for cert a year, what does that mean? Does every judge read all 10,000 petitions? And the answer is some of them do. or some of them make their clerks do. But others have sort of joined in this time-saving device known as the Cert Pool. And the Cert Pool is simply all of the clerks from the judges who are participating in the Cert Pool get together and evenly divide up the petitions for cert and make recommendations individually that certain cases should be heard and not heard. So what this means is that functionally, an individual who's 24, 25, 26 years of age directly out of law school is deciding what cases the Supreme Court should hear, or at least making recommendations to the Supreme Court as to what cases they should hear. All studies that have examined this process have come down to the fact that they aren't biased ideologically. So it isn't conservative clerks recommend hearing cases that conservative judges would want, or liberal clerks recommend hearing cases that liberal judges would want, but they're biased in different and subtle ways. So the Cert Pool has been critiqued, and there's a reason why a couple judges sit outside the Cert Pool. So the one that I can remember off the top of my head is Justice Alito is not a member of the Cert Pool. So himself and his poor clerks have to review all of the petitions themselves. They don't get this wonderful time-saving device of the Cert Pool. But that kind of starts us off on this idea of oral arguments, that these cert memos are circulated year-round. There's no break from them. Oral arguments begin to be scheduled during their summer break. And the cases begin being heard in any given year on the first Monday in October. So the first Monday in October is when the Supreme Court sits. It sits directly after what is known as Red Mass. Red Mass is a tradition of the court to all go to church together and have a mass said in their honor, because there's nothing more ironic than the most powerful judiciary in the United States all going to church together before they decided on issues of legality. But that is, tradition. So once these cases begin to get scheduled, there is a submission of briefs. And what that means is that both parties will submit briefs urging the court to decide in their favor. But also this opens up the time for amicus curiae. Amicus curiae simply means friends of the court. And what they are, what they do, is they urge the court to decide in one way or another, but they're actually not parties to the case. They're interested parties in the outcome of the case, but they're not parties to the case themselves. This is really one of the few avenues that individuals can engage in what we think of as judicial lobbying, is that you can urge the court to decide in a certain way while not being a party to the case. So these amicus briefs are useful, and their deadline is usually a few weeks before oral arguments are actually scheduled. If you ever want to listen to oral arguments, go to OYA. If you just click through this link, it would pop up to an oral argument, and OYA does it very well. Because of our virtual nature, we're not going to do it. But the way in which oral arguments work is each side in a Supreme Court case has 30 minutes. That's it, in totality. And one would imagine that if you've got these 30 minutes, that you want to use all these 30 minutes. Can anyone submit an amicus brief? No, they have to have approval of one of the parties in the case or approval of the court themselves. So not just anybody, although mostly anybody. They just have to get approval of one of the parties in the case. Not a huge barrier, but I will tell you this. There is definitely a financial barrier to it. The average cost of a Supreme Court brief last calculated is around $120,000. Now, what that doesn't mean that it costs $120,000 to submit a brief to the United States Supreme Court, but drafting, putting it together, attorneys filing and attorneys working on it, all of that process has been calculated on average to be $120,000. So there is a barrier to entry, at least there. But in terms of who can actually submit, you just have to get approval of one of the parties in the cases. So some Joe Schmo can't just submit a brief to the court. They would have to get approval of one of the parties. And so the parties themselves serve as a sort of barrier in that regard. But so both parties get 30 minutes before the United States Supreme Court to argue the case. But the thing is, they don't really get 30 minutes because the Supreme Court interrupts them almost constantly to ask questions and for clarifications and to pose hypotheticals and to do all sorts of things, except let these poor individuals talk and advocate for their side. They continue advocating. It's just they're just very often interrupted. I would urge you to listen to the United States Supreme Court oral arguments at some point, because it's very, very interesting if you haven't before. You can also listen to Texas Supreme Court. It's online. It's on YouTube. They're probably live streaming a case right now. A lot of courts in pandemic times have turned to holding their oral arguments, A, remotely, and B, online. And the Supreme Court what is among them. Yeah. So another question. I assume there are organizations that help with that cost? No. I mean, it's a cost. It's going to cost that much. Even a nonprofit organization is going to spend about that much in terms of drafting a brief. Now, can you draft briefs that are less, that cost less? Sure. They're not going to be as good, most likely. It's, and like I'm telling you, it's not like a sticker price. It's not like the Supreme Court asks for $120,000 where you can submit a brief. But the average cost of submitting a brief to the court, getting all billable hours, drafting, writing, paying for attorneys and everything is about $120,000. Yeah. So significant barrier to entry. Now, are there nonprofits who will happily pay that? Yeah. UTEP, professors at UTEP, even in my time here, have been party to Amicus, not party, but have been authors on an Amicus brief. They weren't the ones funding the bill, but you have to understand, them putting hours into drafting it is cost. I don't do stuff for free. The reason why I'm teaching you is because the University of Texas at El Paso has decided to pay me to do that. But if I'm drafting an Amicus brief in my spare time, that's billable hours to somebody. And if I'm not getting billed, if it's not billed, it certainly would cost. So if someone asked me to do that, I would charge them a significant amount of money to do that. So the average cost means in terms of hours and labor. Does it actually cost that? Like real hard-earned money? No. Some people will donate their time. If someone asked me to weigh in on, for example, an issue that I'm involved in outside of research, immigration, I absolutely would, and I would help draft it for free. But if someone asked me to do it outside of my own like pet little issue area, I'd absolutely charge them close to $300 an hour to do so. And I'm cheap. Real cheap. Just think. Remember, Rudy Giuliani wanted $20,000 a day to represent the president. Me doing $300 an hour to write an amicus brief is overwhelmingly cheap. So $120,000, not all that expensive, but also not real sunk cost either. So amicus briefs brought up more often by organizations than by individuals? Yeah, almost always. It's very rare to see an individual doing an amicus brief. It's almost always organizations or collections of individuals. Yeah. It's just, if you're an individual who's not an attorney, then yeah, you'd have to hire attorneys, and then you'd have other individuals participating. And yeah, it just doesn't happen. More often, individuals and organizations pool their resources in order to draft an amicus brief, so that the cost is more spread around, so to speak. Yeah. So opinion assignment is this little fun game that the court plays. So when they take a vote to determine which side is going to win, they vote in order of seniority. So the most senior member votes first, which is the Chief Justice. Chief Justice is always the most senior member of the court. And then they vote in seniority order so that the most recent justice will vote last. The most recent chosen justice will vote last. Then the most senior member of the majority coalition will decide who is going to write the opinion. In most cases, especially on the current court that we have, the most senior member is going to be the Chief Justice, and the Chief Justice will decide who is going to write the opinion. That part is obviously strategic for a number of reasons, but there are also some just workload considerations as well. You're not going to consistently assign yourself the opinion, or else you have to write 75 opinions by the end of the term, and so you're going to spread that around to other judges. The opinion is then drafted and then it's circulated. And the reason why it's circulated is because edits can be absolutely made up into the point that it's published. So even though you say, okay, Justice Thomas, we'd like you to write the opinion in this case. Well, Justice Thomas will write the opinion, then he'll circulate it to everyone. And they will argue and bicker and strategize over how to actually get that opinion out. And they'll argue over text, they'll argue over points of law, they'll argue over focusing on some parts versus other parts. And so they debate and argue back and forth about the content of the opinion, totally up into the fact that if, let's say, for example, Justice Thomas writes an opinion that the fifth judge feels he can't join, then Justice Thomas's opinion, his majority opinion, could become a dissenting opinion if the fifth judge joins the other side of the vote and they end up writing a majority opinion. So all of this is overtly political, just entirely behind closed doors, so we don't see it as it happens. We see it after the fact, usually 20 to 30 years after the fact, when judges release their private papers.